A lot of it is about items that are just not included in agreements. It's like you don't know what you don't know. So people will come to me even in the context of, I act as a mediator sometimes instead of an attorney for someone. So I'm helping a couple try to facilitate an agreement between the two of them. And sometimes people will come to me after having really discussed the terms of their divorce at length. And they'll actually have a list of things, and they come and they say, we have our whole agreement here. And they have, or we've agreed to all the items, and they hand it to me. And it's great that they've agreed to a lot of the items, but it's never all of the items that they need to consider. And it's only because they didn't know they needed to consider them. Sometimes they leave out issues regarding taxes. That's a big one. Sometimes they leave out, which could have big implications. Sometimes they leave out issues regarding life insurance, which again could be a big thing. Sometimes they have an alimony provision in there, but they'll say the amount of alimony, but they won't say the term of the alimony, how long the alimony is supposed to last. Sometimes they'll use the term non-modifiable, or they'll say that something's not modifiable, or they'll say something's modifiable, but they don't really understand legally what that means. Sometimes they say something, can be changed, but they don't say how or why. They don't give the judge. Sometimes there's a legal benchmark that they don't know about, but sometimes there's no benchmark, but you have to, the more specific the agreement for a judge looking at it later when you don't agree is going to save you time and money. It's better to hash out all those possibilities now. People tend to gloss over things when they have an agreement. They don't, especially if they're in court, they want to get it over with. It's a painful process. They don't want to be here. They want to just be done with it. So even if in their mind they're thinking, well, what if this doesn't work out right? They don't necessarily spend the time working on that or bringing it up or asking it, because that's going to cause more disputes, or that's going to cause an argument where everyone goes towards easy, right? Easy. So part of my job as a mediator, when people are in the room, is to bring up all of those uncertainties and to bring up all the items that might not be there, or maybe something they don't have an agreement on. And it's far better to at least be aware of those possibilities and hopefully try to hammer those out now. Or say, if this happens, then we're going to do this, than to leave it blank. Because if you don't address these issues, then either you're giving up rights that you didn't know you were giving up, because maybe the law just takes over, right? Or because if you didn't have something in there, it means that there is no order and there can never be an order about something. Or you're leaving it up to chance as to what's going to happen, what a judge is going to rule down the road, and maybe that's not really what you intended. For quite a few years now, Connecticut has allowed something called partial representation or limited scope representation. We call it a-la-carte representation. So you can hire an attorney, if you can't afford it for your whole case, you can hire an attorney for bits and pieces of your cases where you think you might need the most help. We've always done free phone consultations. We've always wanted to make ourselves available for people just to get procedural information, price information, and just to, determine whether or not they'd even think about using us or want to use us.